Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that converts legal jargon into legal ease. Now, tonight we'll be discussing the question of bail. Just by way of background, according to the South African Survey 2016 published by the IRR last month, some 7,468 detainees were held in South African jails, and in 2015, because they couldn't afford to raise bail, 76% of the detainees could not afford bail set at amounts of 1,000 rands or less. These individuals are in many respects prisoners of poverty. Now, this is a term used by the Institute of Race Relations, and they have argued and urged lawmakers to reconsider policies relating to bail in South Africa. A breakdown of the detainees who could not afford bail is as follows. 3,339 were remanded as detainees, or 45% of the total could not afford bail of 500 rands or less. And some 334 or 31% could not afford to pay between 500 and 1,000 rands. And about 1,082 or 14% could not even afford bail set between 1,000 and 2,000, and a further 589 of 8% of the total could not pay bail between 2,001 rands and 5,000 rands. And 124 of the remanded detainees were set bail's amount of over 5,000, and they couldn't afford to pay the amount. Now, the Institute of Race Relations, Kerwin Lebone, has argued that the figures are concerning for various reasons. The first is that a great many people who have not been convicted of any crime are in jail simply because they are too poor to afford bail. They are what the IRR describes as prisoners of poverty. These are people that the courts believe could be released back into society pending trial, but they cannot afford their freedom. Secondly, the presence of so many remand detainees in our jails compounds the prison overcrowding crisis faced by the Department of Correctional Services. And thirdly, there's a significant cost to the taxpayer in housing this number of remand detainees, and these resources could be more effectively employed elsewhere in the criminal justice system. And the Institute of Race Relations has suggested the South African lawmakers reconsider bail policies to alleviate the burden on both correctional services, the taxpayer, and poor people. Now, experts in this field are joining us tonight. I'm joined by Sarfaraz Qazi of the firm Ismail and Associates in Johannesburg.
Yes, that is
Sarfaraz, Assalamu alaikum and welcome.
Wa alaikum salam. Firstly, I must say Jazakallah for having me on the show. It's a pleasure, and Ashraf, thanks to you as well for having me, allowed me the opportunity to be present and to hopefully give our listeners and viewers some insight as to the criminal justice system and more especially the concept of bail.
Now, you know, bail is usually very, very confusing. Now, what are the common misconceptions that people tend to have when a police officer attends the premises either to effect an arrest or follow the procedures in relation to verifying an accused address? Some of these, what are these misconceptions? How do we deal with them?
Okay, I think firstly we need to break this down in terms of the two aspects. The first one is in terms of the verifying the address, and the second one in terms of the police officer physically coming to your property to arrest you. Let's start off by the verification of the address. Okay, so in terms of the Criminal Procedure Act, one of the obligations of the investigating officer is to verify that the person being granted bail is actually residing in South Africa within a specified address that that particular person states. So remember, when that person is arrested, he is not present to verify expressly where he stays. He merely indicates to the investigating officer that I live at X and Y address. The obligation then is on the investigating officer to visit that particular address and verify if that particular person stays there. So what happens sometimes is that a person staying in that particular house or a family member obviously see the police officers there, and we being human beings are scared of the police. So the first reaction that comes to our mind is to say, let's tell them a lie, or let's try and change the topic, or let's tell them that that person does not stay there. But the reality of the situation is that if you do that, that merely prolongs the person's right to be granted bail, in that the investigating officer can no longer fulfill his duty. So I think in terms of that, and in that respect, it is utmost important and essential for the person, the family relative or the friend, to verify and to confirm that that particular person stays there, because given that this is an important consideration in the granting of bail, this would materially influence that person being granted bail. In relation to the second aspect of the a physical arrest by a police officer who comes to your residence, that could happen in a number of situations. The first one would be where there's a warrant for your arrest. The police officer would come, then show you your warrant, read you your rights, and arrest you. Remember though, that might not necessarily be a police officer who's in uniform. That could actually be an investigating officer who's driving an unmarked car, who's wearing a layman's clothing. So I think a common misconception is you see somebody coming, you then doubt that person. As long as they've obviously got credentials to verify and validify the fact that they are police officers, it's not necessarily important for them to be dressed in uniform. Also, in terms of the arrest, they could arrest you in terms of a warrant, as I firstly stated. They could arrest you without a warrant, and also they could actually come with the complainant, a complainant being the person who has opened the charge against you, to basically come and point you out and arrest you in terms of that.
So thank you for that. So there's two possible scenarios there where a policeman could pitch up, and it could either be to verify your address, but I suppose that is where you're already now charged, right?
Yes.
So he could come when you're not there, or you could be charged and you're going to appear for bail, and then he comes to verify your address.
Yeah, I think basically what would happen is you already charged, they already arrested you, and part of the charging process, if I can put it that way, is to verify your address and to verify that you stay there. So 99% of the time, the person won't be present to verify his address unless he's escaped.
But I mean, there's other family members that he could speak to. Now, what are the fundamental requirements for a possible bail application to take place?
Okay, I think there are two more fundamentally important aspects as opposed to other more relevant aspects. The first one is, as I said, or as we discussed previously or now, was the address verification. The second one, and which is becoming more common now, is the profiling of the accused. In layman's terms, that means the police officers go into their records, pull a report to see if there's any previous convictions, pending cases that this particular accused has, and based on that they can then assess what type of an offense it is, which we'll get to at a later stage. And that I would understand, those are the two most essential criteria in assessing bail.
Okay. Now generally we say that one, we said, was the address, and two was when the accused is put in the box, one of the fundamental things that the magistrate would ask the defense to make a comment on, or the defense would volunteer, is, are there previous convictions or are there any outstanding matters against you? If that is so, and you lie under oath, that bail application could be in serious jeopardy.
Definitely so. In common terms, it's called the penal clause. The magistrate would explain to every accused that if he lies under oath in relation to this, there is a fine coupled with and/or a sentence, which the court views in a very serious light. Because sometimes an accused would come and try and hoodwink the court. But remember that if the profile is not before court during the bail period, it would come to court during the sentencing period. And if in all likelihood the court's going to find out about this, and that would result in an additional imprisonment or fine to the accused.
Now another misconception is, if you are arrested, does it automatically mean you are guilty?
You know, I laugh on that topic because when we started off articles, when we were young and vibrant in the careers, we also had that same perspective to think if you were arrested, you're guilty. You automatically said, I don't want to do a bail application. But the reality of the situation is no. That is merely the start of a process. And bail is actually to the advantage of the accused because he's obviously his rights in terms of freedom, in terms of the Constitution, is then being exercised in terms of which he's given an opportunity to substantiate the fact why he shouldn't be held in custody pending the actual trial, which will actually transpire thereafter.
Now, you know, usually people are quick to say that we want our time in court. We want to say now, I'm not guilty. And I mean, we've seen so many examples of this recently as well, that people want their day in court.
Yeah.
So what is the best advice that you can give to an accused? Because that's now, he's been charged, he's probably going for bail, he wants to say a lot, but he doesn't understand there's a two-step process: bail and then trial. And you don't have to plead guilty at the bail stage. You just have to satisfy certain requirements, right? So what is the best time for him to give his version?
I think, wholly speaking, that's very factual in relation to the specific type, the specific accused and the type of offense. Naturally speaking, it is advisable that when you are arrested not to basically give a statement, to observe your right to silence. They cannot force you to give a statement. However, you can give a statement if you want to. Right. Now, what's important there is sometimes people jump the gun and feel, I'm going to give a statement, and in terms of my statement, I'm going to put forward X, Y, and Z, and I'm going to be found not guilty. Yeah. But what they don't realize is you might give a statement that will incriminate yourself. For example, you might say, I punched the person, because you're a layman. We don't understand. Yeah. But you won't say because he punched me first, for example. Right. Which is self-defense. Which is self-defense. So what would happen then is automatically you're putting a version before the court, which then when you get to the trial stage, the court would then have to rely on that and look at it and say, why are you saying X now and why are you saying Y now? But then also, there might be circumstances which would command that you basically give a statement. For example, if you've got a case where you were not, alibi, where you were not at that particular place at that time, if you put it in an affidavit, it's not going to incriminate you to the extent where it's going to affect your trial. But what could happen then is, when the matter goes to court for them to say whether they want to proceed or not, the person or the prosecutor reading the docket, deciding whether to proceed, will then read it and say, hold on, I'm not going to place this matter on the roll because 9 out of 10 times the accused has a compelling or a good enough reason to justify his cause. Right.
Okay, time for a break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh. And here's a reminder that you are tuned to Legal Ease, the show that converts legal jargon into legal ease. Tonight we are joined by Sarfaraz Qazi, who is an expert in the area of bail. Now, Sarfaraz, just before the break we were talking about different schedules. We're just touching on schedules. What is a schedule, first of all, and why is it important to classify an offense under a schedule?
Okay, let me start by going back. Initially we spoke about a profile and in terms of pending cases and previous convictions. So in terms of the law and the Criminal Procedure Act, on a periodical basis it regulates the different types of offenses and the different types of requirements that need to be met in court in terms of these different types of offenses. So the different types of crimes would then fall under different types of schedules. An example of such would be, you would have the very minor crimes would be a Schedule 1 offense, right?
What, like shoplifting?
Yeah.
Okay. Then so there's no violence involved?
There's no violence involved.
Up to the extreme on the right-hand side, Schedule 6 and 7.
Schedule 6, right. Then you'll obviously have your Schedule 6, which are your more serious offenses. Then you'll have
murder, rape, robbery, housebreaking.
Yes, those are the exceptional exceptional circumstances offences, if I can put it that way. So that's the one scale to the other. And then in between, you'll have a Schedule 5 and Schedule 7 offences, right? In terms of the relevant offences, the requirements in terms of the law to prove those offences differ according to the type of classification.
Right.
So a Schedule 1 and a Schedule 7 offence, the onus would be on the prosecution to show why that particular person should not be granted bail.
Okay, so it's on the prosecution.
It's on the prosecution.
All right. Just a reminder to our viewers, I just want to remind them that our lines are open, and as usual, and we apologize for the number not appearing on your screen. We have a few technical glitches tonight. So to remind you, it's 011-086-7777. Please feel free to call in and join the discussion on bail. So we're speaking about the onus being on the prosecution in certain instances.
Right. Then we go on to Schedule 5 offences. Schedule 5 offences are less serious offences that are not Schedule 6 offences. Example, murder, it's like culpable homicide, etc.
Right.
Right. In terms of Schedule 5 offences, the onus lies on the defence. It's called a so-called reverse onus policy, in terms of where the defence needs to show that circumstances exist to justify that the accused should be granted bail. This is usually done in an affidavit form.
Right.
Right. In terms of this affidavit, the personal circumstances of the accused are put forward to the court.
Yes.
The nature of the offence, the previous and pending convictions, pending cases. And in terms of that, I would say, in terms of our experience, 80% of the time, those individuals would get bail.
Right.
Right. Then we go on to the more or the most serious offences, which are your Schedule 6 offences.
Yeah.
In terms of those offences, murder being an example thereof, the onus lies on the defence to prove that exceptional circumstances exist that would allow the accused to be released on bail.
Okay.
Right? In terms of these exceptional circumstances, these are very, very compelling circumstances in terms of which case law would dictate what these circumstances are. But if I could just indicate that the court takes into regard personal circumstances as an exceptional circumstances. For example, a sole breadwinner of the family.
Right.
If he's no longer employed, what would happen to the family?
Yeah.
The court would then take into regard the nature of the offence. And in terms of these offences, a version has to be put forward.
Right.
Essentially, this is a situation where at a very early stage, you need to put forward a version as to what happened to allow the court to ascertain what the circumstances behind the case is.
Isn't a good example of that is Oscar Pistorius. I mean, the first charge was not murder but culp. Then, in order to be released on bail, he had to proffer a version, and that's how it was clearly established that the facts are that he had created, or the dolus eventualis, I know it's a technical term, but our job is to convert legal jargon into legal ease. So, the dolus means intention, eventualis is what the court imputes to you, irrespective of what you say. For example, in Oscar's case, right, he intended to shoot a human being through a closed door. So that meets the definitional requirements of murder. And that's why the court said you could never not have foreseen that somebody would be killed or injured. So therefore, you form the intention to kill. Even if you subjectively say, no, 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 and the court says, no, no. When we look at all the circumstances, that intention was there. So what you're saying that in certain cases where you have the onus, you now have to put that version to the court. But that can be quite devastating for you in the long term, as we've seen.
Most definitely so. I mean, we've had a case recently, armed robbery matter, where the personal or the actual version of the client was put forward, and in the trial itself, questions were raised as to what was put forward. And remember, sometimes you will be eager to get out on bail, and not realize the impact that your version will have on your ultimate case, which will result in a harsher sentence as opposed to just bail or being refused bail. So I think the version that is put forward on affidavit number one.
So that's a sworn statement, and you can't get out of that because that's what you said. Yeah.
That is indeed correct. So in terms of Schedule 6 offences, once you put a version, you show personal circumstances, and the court will then consider as to whether to grant bail. And to be perfectly honest with you, Schedule 6 offences in our past and our history, we've got a 50-50% rate.
Right.
In terms of, you don't know which way the magistrate is going to swing. Most of the time, if he reads the version, if he views it as a version that's plausible and justified, then they would grant you bail. But if you just merely neglect to put a version, you're going to get denied bail under those circumstances.
Now, I mean, in further misconceptions, but before I do that, here's a reminder to you, dear viewers, the lines are open. You can call, discuss bail. Is there bail for domestic violence, for example, which we can talk about? So the number is 011-086-7777. The lines are open, and Sarfaraz is waiting to take your calls. So, common mistakes that people make. You know, we see this all the time because the layman doesn't always have the benefit of an attorney, right? And like you're saying, he could make a statement, it's under oath, and it's there forever. And at other times, you may have a very, very good defense. For example, as you pointed out, self-defense. I think Oscar also tried that at one stage. It says he really feared that his life was in danger because if the intruder exited, then he would have harmed him and Riva. But that wasn't clear because there are very certain parameters before you can say you acted in self-defense. The attack must have commenced, etc. But that's not the topic for tonight. So common questions when an accused is arrested and then released on bail. How long does this process take to finish?
You know, the process, again, it's wholly dependent upon the type of offense, the nature of the offense, the nationality of the accused, for example. Well, we'll get to the issue of bail of foreigners at a later stage.
Right.
But what happens in the normal course of events is you go through the bail application. Normally within 48 hours, the accused must be brought before court, or in terms of police bail, if it falls under certain...
No, sorry, what is police bail? Because again, people say police bail. And does it mean the police give you the bail?
That was actually a good question, which we should have probably discussed at the earlier stage. But essentially, police bail is bail that the Criminal Procedure Act as well as the schedules allow that a police officer on his own can grant an accused bail. Those would be, for example, drunken driving, trespassing.
So this is now after the courts have closed for the day. It's like night, right? The night bail or weekend.
Yeah. So basically, how it would work is once there's an investigating officer that's allocated to a docket. So on the normal course of events, the complainant would go to the police station, lay a charge, a docket would be open, would be then allocated to an investigating officer.
Right.
That particular investigating officer will then assess the gravity of the charge and the offense and decide, okay, do I need to arrest this man today or tomorrow?
Yeah.
During that particular stage, when the docket is allocated to the investigating officer, then already, if it's a police bail, it falls under the police bail ambit, would the police then be already, after taking fingerprints and charging the accused, would you be eligible to be granted bail by the police?
Right. So it's a whole process.
It is a process. But in terms of that, that's what they've sometimes called after-hours bail.
And do you need an attorney? Because sometimes the client calls and says, the police officer is willing to give me bail, but I need an attorney.
You see, under certain such situations where a police officer is granting you bail, you don't necessarily need an attorney. right? Sometimes it's important to have an attorney there, so try and mediate between the police officer and get him to do things.
Yeah.
Certain times, maybe we forgot to also mention this, is certain schedules allow for a prosecutor to come to the police station and to grant, together with consideration and speaking to the investigating officer, to grant the accused bail. For example, would be a good example of that would be assault GBH.
Oh, okay.
So if the prosecutor comes to the police station, or you go to the court, depending on which areas it falls within, that particular prosecutor, in speaking to the investigating officer, can grant you bail the 12 o'clock at night.
Okay. So that's going to be another good place to pause. We're going to come back to getting this prosecutor out to grant you bail at night. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Just before the break, we were talking to Sarfaraz about the possibilities of police bail, but I understand we have a call on the line. Caller, please. The caller will come back to us. Our number is 011-086-7777. So there are instances when you can actually call a prosecutor out and talk to him and arrange bail.
Yep, definitely so.
Are they willing to do that?
It depends, but I see most courts now have a standby prosecutor with a standby phone number. And if you can get a hold of that number, that particular prosecutor...
Sarfaraz, I ask you just to pause, please.
Sorry.
We have a call on the line. Caller, please go ahead.
Hello?
Hello, we can hear you.
Yes, Assalamualaikum.
Waalaikumsalam.
Sorry, can I proceed with my question?
Please do so. Please speak up a bit.
Okay. I just want to find out, say if a person is arrested over the weekend.
Yes.
And I understand that the police have 48 hours to make you appear before court. Right?
Yes.
Is it 48 hours including the weekend, or is it 48 working hours?
Very good question. Thank you.
Okay, the 48-hour rule does not include the weekends. So if somebody is arrested, for example, on a Friday morning, the onus then is on the police to bring him to court on a Monday. So sometimes, if police officers want to be vindictive, they would come and arrest you on a Friday afternoon, just so they know the 48-hour rules don't apply. So for that particular period, the 48-hour period is suspended for the weekend.
Including public holidays, I take it?
Including public holidays.
So if he comes on a long weekend, the next working day is the only time that you're going to have to apply, or the possibilities.
But sometimes it works to your advantage, because what happens is they get lazy and they don't want to come with the docket to court on the Monday, for example, on the morning. And then what happens is, in order to avoid an unlawful detention, they then release the client without proceeding with the matter further. So sometimes you create a big hoo-ha and you notify them of such. It will either force them to charge the accused and bring him to court. If you keep quiet, sometimes you can get a substantial amount of money in terms of a delictual claim for unlawful arrest.
Okay, I hope that answers your question.
Okay. And I just wanted to verify something else.
Yes.
If a person is arrested, does the state have an automatic right to ask for 7 days postponement to verify the accused's address?
Excellent question.
That is indeed the case. If you look at a foreign citizen and verification of the address, if that's not supplied to the investigating officer, hence our first discussion that if the investigating officer comes out to the place and if the person says there that the person doesn't reside there or there's any issues in relation to that, the police officer can then object to bail on the basis that that particular person's address hasn't been verified, and they can request between 7 to 14 days to actually verify that particular person's address, which will result in that person being in custody for that period of time.
You're welcome.
No problem.
Amazingly, I must say that recently I did a matter and we challenged the 7-day rule, and we found that it was only on application. It's not automatic. I think what he wanted to know was, is it automatic? And I think the misconception is that it is automatic. So it's on application.
Definitely.
And there has to be a justification. But you can actually preempt that. You could have your evidence ready for your proof of address, especially if you're a business person and you haven't gone away and you have a place of work, etc.
Ideally, in relation to that, what would happen sometimes is if there's an objection to the address verification, the accused family can be present in court.
Yeah, and
the defense can say, we've got a utility bill,
yes,
and an affidavit by the mother, for example, to say that he's staying here. Can we hand this up to the magistrate as proof to the satisfaction that his address is verified? In that circumstances, most magistrates would then say constitute that as sufficient. However, obviously, it's a question of the magistrate concern and whether they're willing to accept
and
it.
the investigating officer could put certain things up and say, we want to still challenge this. Now, please, as another reminder, we have just a few minutes left. Call in with your questions. The number is 011-086-7777. I think we were making a point that the prosecutor can come out and there is a standby prosecutor. So where would you find these details?
Normally, the police stations, they have boards in terms of which they have a standby list of the investigating officers and the prosecutors. If you don't find it there, you got to make a call, ask the investigating officers, and it's basically, it works in terms of that.
Sarfaraz, we have a call on the line.
No
Caller,
problem.
please go ahead. Okay, sorry, we've lost him. Sarfaraz, I think it's also quite easy if they call you, because you'll probably save them a trip in the middle of the night to try and get into a magistrate's court. I'm sure in your area of speciality, your firm does a lot of bail applications.
Yes.
In the event that there's bail, and you'll probably have a list that we have another call on the line. Caller, please go ahead. We can hear, yes, we can hear you.
I can hear you. Yes, in terms of protection order, I'm supposed to attend a protection order on the 6th of April. What should I do to prepare for it?
Okay, so your question is not bail. Your question is how to prepare for the date for you to appear when there is a domestic violence order against you.
Yes, sir.
I think, although it's not related to the topic,
Yes.
we could give the learners some advice. Basically, it depends whether, firstly, on a protection order, they grant an interim order, which is an urgent order, and then a return date, in terms of which you can either argue the matter on viva voce, verbally, or on application or affidavit. What I suggest, though, is you either contact an attorney or a legal aid attorney, if needs be, on the day or prior to the day in question, to assist you to adequately prepare to either postpone that matter to supplement your affidavit in response to whatever the initial affidavit was, or alternatively postpone the matter for arguments in terms of trial.
Okay. Are you still with us, caller? Okay, we have another caller. I hope that answers. We have another caller. Please go ahead.
Okay, I'd just like to find out, someone is arrested with 2 firearms, both licensed firearms, but without his licenses. Is it possible for him to get out on bail, or will he sit until obviously our great lawyer can take him out?
So, if I understand your question clearly, you have 2 firearms, both of them are licensed, but you don't have
Yes,
the
sir.
license with you physically,
Yes, sir.
and you've been arrested for that.
Yes, sir.
Can you get bail? That's your question.
Okay.
Yes,
Sarfaraz?
that's my question.
We've had a case that has come up recently where a client had a firearm as well. He didn't have the license on him. However, the police officers, they used the serial number to then verify the possession or the owner of that particular firearm and withdrew the charge based on that.
But I think the answer is yes, you can get bail, because the offense is not to possession of an unlicensed firearm. It's possession of a licensed firearm without a license. It's like driving without a license.
Yeah. They shouldn't be reason for bail to be refused under those circumstances. It doesn't fall within Schedule 6. Subject to correction, I think it falls within Schedule 5.
Schedule 5. Okay, time
Okay,
for...
and one more question. Basically, I cannot renew my licenses because there's a case pending. Is it possible for me to get my firearms back with documentation from the police station stating that it's my firearms?
In terms of the case that's pending, what was the order by the magistrate in terms of you being declared fit to possess a firearm?
Was there an order for the firearms to be removed from you?
Look, basically, because I had no license, that's the reason why the firearms were kept. And
Okay.
it was actually at the summit where I was in wrong.
Yeah, but pending the finalization of any matter, you can't get what the state holds as evidence. You can't get that back unless you now go with your license and make representations
Yeah,
and have the charges withdrawn. So you can go with your license, go to the prosecutor, get an attorney, go to the prosecutor and say, look, I was charged with this offense, here's my license, everything is in order.
What I may possibly suggest is that if the caller, we provide him with our details, and
Yes.
he can maybe give us a call, and we can contact him to find out and get more clarity off air regarding this, and we can maybe assist him going forward.
Certainly, just go ahead, because we apologize, the number of our guests is not on the screen due to a technical glitch. So Sarfaraz, please give out your details.
Okay, firm's name, as stated earlier, Ismail Attorneys. My cell phone number 073 6786 938. Alternative number is 073 6786 652. You can either ask for myself, Mr. Junaid Ismail, or Mr. Muhammad, who is also part of our offices. We will
Perfect.
gladly assist you in this regard.
Just give your numbers out again slowly, and your landline as well.
Okay, let me start with the landline number again. 011 492 1758. Cell number 073 6786 938. Alternatively 073 6786 652. And finally 073 6786 425.
So there it is. Viewers, you've got all the contact numbers of our guests. Time for another short break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight my very special guest is Sarfaraz Qazi from Ismail Attorneys in Fordsburg, who him and his partners are specialists in bail applications. We've heard a lot about the different kinds of bails and when you can apply, and can you bring out a prosecutor, or can the police grant you bail. What about the amount of bail and affordability?
Again, personal circumstances and the nature of the offence is taken into account. So whether the accused is the sole breadwinner, what is his current salary, what is the type of offence, is the version put forward something that would put forward his innocence. So wholly dependent upon those particular circumstances. However, having said that, if bail has been set at a certain amount, and if the accused can't pay that amount, he can subsequently at his next court appearance bring an application for reduction of bail, showing the court why he can't afford bail.
So if you're talking about reduction, what about situations that change? For example, he needs to travel, right? And the state has removed his passport. Can he bring an application later on to say, look, I want to review my bail conditions?
Most definitely so. If circumstances change, you can bring an application for bail under new circumstances.
Okay. What about foreigners? I think that's a very important topic. There's lots of misconceptions in law, right? One is that a foreigner shouldn't get bail. Another one is a murderer or a murder accused should not get bail. And often you see public outrage in the newspapers that, look, this guy got bail, etc. But those are emotive responses. I mean, it seems like there are very strict parameters that and procedures that need to be followed. We understood that if you can't afford bail, you can make application. You could even get free bail, right? Or bail free. You could be released without bail.
A warning.
A warning, yeah. So, foreigners?
In terms of foreigners, there's no reason why they should not be granted bail. However, the proceedings in terms of the bail is a little longer, in terms of which the investigating officer is allowed a period of 7 to 14 days to verify the status of that foreigner. Because a lot of paperwork is falsified nowadays in terms of work permits, immigration, asylums. So what we essentially, or what the courts require, is that the investigating officer drives to Pretoria, verifies the status at the relevant immigration office or Home Affairs in terms of...
The reality is, given his workload, it's practically impossible. So here's the advice to the viewers. You have a problem with bail, you have a problem with foreigners wanting bail, granted bail, contact your attorneys. These are the experts in the area. Sarfaraz, we've run out of time, unfortunately. And I have a few seconds to just say thank you very much for coming out and informing us of a very, very important topic.
And I want to say Jazakallah to the listeners and to yourself for allowing me the opportunity and the platform to assist where I can.
Absolutely. And to the viewers, thank you. Without you, the show would be nothing. Thank you for your calls and contribution. Keep well until we meet again. Assalamu alaikum wa rahmatullahi wa barakatuh.